Hi there, and welcome to sydneydrinkdriving.com.au. Hi guys, Josh Borman from sydneydrinkdriving.com.au. I'm here today to update you on a new drink driving matter that I had only last week out at Parramatta Local Court. This matter was quite a serious matter. It was a high range drink driving matter. The blood alcohol reading was 0.166. There was an additional traffic offence attached to this, which was a fail to give way when overtaking. Basically, the matter happened on the M4 motorway in Sydney, and it occurred in the early hours of the morning. My client had been out drinking for a number of hours the night before. He was admittedly well intoxicated, had gone back to a friend's place, only had a couple of hours sleep, and then decided to get into his car and drive home in the early hours of the morning around 7 or 8 a.m. So obviously the blood alcohol reading 0.166 was an issue of concern in the court's eyes, and the fact that there was a fail to give way when overtaking was seen as an aggravating feature to this drink driving offence. Generally, an aggravating feature is a feature of the actual case or scenario which can increase the chances of risk or injury occurring to people in the general public. And certainly this second offence attached to the drink drive was seen as an aggravating feature. My client was only 25 years of age, so he hadn't been driving all that long, had his licence for about 7 years. In that time, he had about a handful of entries on his traffic history, generally speeding, a red light camera, relatively minor traffic infringements, certainly nothing as serious as the high range drink driving offence which was in court last week. My client was academically a very bright young man. He'd excelled in the workplace, he'd done a lot of charity work, he had excelled at university. He was generally a person who held a very good character, and I was able to explain to the court that this was a one-off type of incident that was very much out of character for him, and I was able to also explain to the magistrate and the court that my client had learned some very valuable life lessons coming away from this incident that had occurred, especially after attending the traffic offenders program, which was the fully approved 6-week course run by the local PC Police Citizens Youth Club, or PCYC. He took a lot of lessons away from this, and in particular found it quite a moving experience to attend these sessions. He said the presentations given by the victims of real-life road trauma had really moved him and really driven home to him how dangerous his actions were on the morning of the offence. So I was able to show the court that my client had gone through this course. He had learnt some very strong lessons coming away from it. His history obviously showed that it was quite an uncharacteristic sort of behaviour for him. And we were also able to tender some strong references from his employer, a family member, and also a charitable organisation that he spends some of his spare time volunteering for. We packaged this all together. I was able to present it to the court and submit some oral submissions on behalf of my client. For a high range offence, we were able to get him a good result. For a high range offence, the automatic disqualification period is 3 years. The minimum disqualification period that the court has a discretion to lower down to is 12 months. And certainly we had to play this matter quite carefully because of the aggravating features involved, but we were able to persuade the magistrate with the preparation of our case and the oral submissions to the court to lower his drink driving disqualification period down to the absolute minimum of 12 months. We also sought a specific order for the magistrate to backdate the disqualification period to the time of the offence, because we had adjourned the matter for several months for my client to do a traffic offender program and to prepare his case. So all that time that he was off the road leading up to the court case was taken into consideration as time served under the disqualification period. So my client was extremely happy with the result we got. Generally speaking, it's pretty much the best result he could have hoped for, having a blood alcohol reading of 0.166 in the high range, and especially with a number of aggravating features that were involved in this incident. So guys, this is just one example of a drink driving matter that we represented on out at Parramatta Local Court. We do attend all of the local courts around Sydney, and certainly if you have been charged with a drink driving or alcohol related traffic offence, please feel free to give me a call at the office. My number is 02 9283 8622. I'm happy to have a free first telephone consult with you over the phone to give you an idea of the situation you're in, what you can expect when you go to court, and certainly if you'd like to get us on board to offer you some quality and professional legal representation and get on board a lawyer who is in court nearly every day representing people on these types of matters, then certainly we can discuss arranging representation for you. Your first step, if you haven't already seen our website, would be to go along to our website, which is sydneydrinkdriving.com.au. There is a whole heap of information there relating to drink driving and alcohol related traffic offences in New South Wales. There's articles, there's laws, blog posts, videos, and certainly you will get a better idea of the position that you may be in by visiting our website. And like I said, have a look at that, then give us a call and we can discuss the options that you may have. And please give me a call 02 9283 8622.